All right, Assemblymember Wicks, thank you for your patience. This is file item 18 AB 866. Wicks, thank you.
Thank you. Good evening, everyone. Just have a simple little bill here at the end for you all to consider. Great.
I have a motion by Assemblymember Bauer-Cahan and a second by Assemblymember Lowenthal.
Thank you. Well, I want to begin by thanking Mr. Chair, you and your staff for their thoughtful work and conversations we've had around this policy proposal. I want to clarify for members of the committee as well as the public that while we are discussing the bill today as proposed to be amended, if this bill passes today, those amendments would ultimately be taken before the Judiciary Committee at the hearing next week. AB 886, the California Journalism Preservation Act, provides a lifeline for news outlets and journalists in print, digital, and broadcast media that bear the cost of gathering and reporting news, while large internet platforms bear none. California has lost more than 100 newspapers in the last decade. As news consumption has moved online, community news outlets have been downsizing and closing at alarming rates. It's not that no one reads or watches news anymore. It's that dominant tech platforms, both search engines and social media, have such unrivaled market power that newsrooms are coerced to share the content they produce, which the tech companies sell advertising against, providing almost no compensation in return. Borrowing from similar, although not identical, legislative efforts in Europe, Canada, and Australia, as well as federally here in the US, AB 886 requires large tech companies to pay a fee for accessing and featuring journalism content on their platform. Vitally, the California legislation also requires that 70% of the funds derived from the bill be spent on journalists, ensuring that the funds are reinvested in newsrooms. For this reason, it has attracted the support of both publishers and journalists alike, both of which you will hear from today. Critics of AB 886 have put forth numerous arguments, which I'd like to address now. First argument, tech platforms don't make any money off the backs of journalism. If anything, it's the other way around. My response, if tech platforms were not making money off of news, if it did not have a value that tech had essentially monetized, then it would not be present as a feature of its product. Tech platforms, at their essence, compete for our attention, and access to journalism gives them the vital content that keeps users engaged. This is why in other countries where laws similar to AB 886 have passed, tech has not abandoned its use of news on their platforms. Argument 2, the bill violates the First Amendment. My response, this bill was written to withstand First Amendment challenges, and under its provisions, platforms are not forced to display any content. They remain free to implement their terms of service and other moderating practices. If a covered platform finds a news organization's content distasteful, they can continue to choose not to include it on their site. Argument 3, this bill will incentivize clickbait. My response, I would like to quote directly from pages 10 and 11 of this committee's analysis, which notes that this bill does, quote, have a system where payment is based on the number of impressions online. However, the incentive to get eyeballs and clicks already exists today, so that users will click through to a news site and the publisher will get advertising revenue. In an effort to generate much needed revenue, publishers are already trying everything they can to optimize search results. This bill is unlikely to make them try things they've not already tried. In fact, one could make the opposite argument. It is conceivable that with financially sound books and healthier newsrooms, more engaging and investigating reporting will lead to quality stories based on real events in city halls, school boards, and communities across the state. That will lead to more clicks because there will be higher quality content, not less. As proposed in this bill, 70% of the payment must be spent on journalists. More journalists may equal both more content and higher quality. Argument 4, the entire premise of the bill is flawed. It is simply the internet itself which is responsible for the decline in journalism, and traditional journalism has to die in order for something else to be reborn. My response, the economies which support quality journalism and the technological advances that impact its vitality have never been ignored by American government. Whether adapting to telegraph, radio, broadcast television, and now the internet, our fourth estate has always had the help of lawmakers to bolster its standing because of our shared belief that a free press is vital to our democracy. Allowing rank-and-file journalism to continue to atrophy or die off has never been our country's approach when journalism is faced with a challenge. We have always made space for the fourth estate in our discourse because without it, our civic health is at greater risk. Considering what has happened at once venerable newspapers like the Salinas Californian, where there are currently no more reporters left in this paper, as reported in the LA Times recently, Quote, the only original content from Salinas now comes in the form of paid obituaries, making death virtually the only sign of life at an institution once considered a must-read by many Salinans. A thriving, diverse press is the backbone of a healthy and vibrant democracy. When newsrooms are full, the public reaps rewards, and communities without local journalism suffer consequences, from declining civic engagement and lower voter turnout to higher taxes and increased corruption. This bill is a complicated one, and it's one that I've spent a lot of time working on. I've talked to every single one of you in this committee, but I think it really strikes at the heart of something that we all care about, ensuring that we have a free press to support our democracy. And right now, I think that question is imperative that we tackle it in this body. And so I appreciate the conversations that we've had. I'm going to continue working on this bill and working with the opposition on that if I get it out of committee today, because I know that it is a complicated one. But I would respectfully ask for an aye vote. And with me here to testify in support of the bill are Matt Pearce, President of the Media Guild of the West, and Danielle Coffey, Executive Vice President and General Counsel for the News Media Alliance.
Good evening, Chair. My name is Matt Pearce. I am President of Media Guild of the West, a local union of the News Guild CWA that represents news workers in Southern California and across the greater Southwest. For the past 10 years, I have been a reporter for the Los Angeles Times, where I've had a front row seat to the devastating decline of local news in our state. I've watched countless reporters disappear, beats go unfilled, and communities go uncover. I testify here on behalf of around 1,000 reporters, photographers, editors, and other media workers who work day and night to bring the news to millions of Californians. Rank and file members of my union voted unanimously to support this bill, and we are joined by our sibling news guild local, the Pacific Media Workers Guild in Northern California. Many policymakers have lately started asking if our communities should be satisfied with the world that Google, Meta, and other massive tech companies have built for us. We are 2 decades deep into the platform revolution, and it's clear that the economic foundation for local journalism is continuing to fall apart. Community news should be flourishing. Instead, we are drowning in conspiracy theories as newspapers die and public officials go uncovered. It's not because journalists don't want to cover you or because voters don't want to read about you. And just an aside, I just watched 6 hours of hearing of the most boggling array of policy issues to appear in front of this body, and I'm thunderstruck that this room is not absolutely crawling with journalists. This right here is the issue. But I have members of my local who make $35,000 a year and are struggling to make rent if they can even hold on to the journalism jobs that they still have. The California Journalism Preservation Act would help level the playing field between platforms and publishers and help bring journalism jobs back to newsrooms across the state. The platforms would have to fairly compensate publishers for crawling the journalism we produce, including for training artificial intelligence models that use our work. 70% of these revenues would have to be directly reinvested into newsrooms. This is a good start. I respectfully ask this committee to support this bill to give local news a fair shot to survive in California. Thank you for your time.
Thank you, committee and committee members and chair. My name is Danielle Coffey. I'm with the News Media Alliance. I'm a national association representing 2,500 news publishers and magazines across the country. News publishers' audience and the demand for our content have grown exponentially over the past 10 years because of the internet. So the trajectory of the demand is upward. However, the decline in our revenue is the opposite trajectory, which does not match. And there's a reason for that. There's 2 dominant platforms that sit in between us and our readers. They distribute our content, they monetize our content, and they don't return that revenue back to the content creators. Google and Facebook systematically and deliberately feed users our content to drive engagement. They do so within their walled gardens in personalized feeds so that they can collect your user data, your personal information, and then target you with advertising. In fact, 65% of people, users, do not leave Google, and 95% of users do not leave Facebook and click through to our website so that we can monetize our content. This bill would address that marketplace imbalance. between monopolies who no one publisher has the ability to withhold their content from, because a willing participant does not mean that you're getting your fair market value. What this bill would do, it would allow arbitration to ascertain that fair market value and return that back to the content creators. In doing so, you would level the playing field between the dominant platforms and those who create the valuable journalism that communities across this state enjoy. This has been done, like Assemblymember Wicks said, in Australia. It was successful. It was the equivalent. It was 140 million there, and that's the equivalent because of their market share to billions here. And the market share of California is significant when it comes to proportion of the national economy. This is an opportunity for California to lead and address this critical issue for the free press and for our democracy. And I thank Assemblymember Wicks for her leadership in championing this for our industry.
Thank you very much. Are there any others in the hearing room in support?
Good evening, Brittany Barsai with the California News Publishers Association, proud co-sponsors of the bill representing 800 publications throughout the state of California. Also in support, we have the American Economic Liberties Project, the National Newspaper Association, the National Press Photographers Association, the Radio, Television, Digital News Association, the Authors Guild, the San Fernando Valley Sun, Picket Fence Media, which includes the San Clemente Times, Casperino Dispatch, Dana Point Times, the Los Angeles Blade, and also the San Francisco Chronicle. Thank you.
Joe Barry with the California Broadcasters Association, representing all the radio and TV stations in California in support of the bill.
Good evening, Mr. Chair and members. Steve Cruz on behalf of California Black Media. We are in a tweener category. We've had good conversations with the author and the sponsors, and our members just want to have the opportunity to understand how the binding arbitration will work and the usage fee, and make sure that the ethnic media are adequately included in those conversations. And so we look forward to those conversations, but that is our position for tonight.
Thank you very much, Mr. Cruz. Now we'll say, is there anyone in the hearing room in opposition to the bill?
Good evening, members. Thank you so much for taking the time to hear us today. My name is Catherine Trendacosta. I am the Associate Director of of Policy and Activism for the Electronic Frontier Foundation. More importantly, I'm a former full-time journalist, current freelance journalist, who had to leave the world of digital media for the well-paying and secure world of nonprofits because of the state of digital media. So when I say that this bill is not going to help digital media, I am very serious about it. I was one of the people who organized the first digital union shop in New York City. I am incredibly passionate about the opportunities that the internet gave to people like me to become journalists in comparison to the general trend of media, which is towards straight white males. This bill is a wealth transfer to the same billionaires, vulture capitalist funds, and giant conglomerates that bought up newspapers for pennies on the dollar because of the devaluation made by big tech. And so the idea that they would reap the rewards is incredibly offensive to me. And I know the arguments are that 70% go to newsrooms. I would say that these companies, motivated by profit, will put that 70% in newsrooms and take 70% back out and use it to line their pockets. They will not be using it for journalism. It will also incentivize clickbait, because if you're being paid by the view, then you are going to be incentivized to do that. And the companies are going to be incentivized not to hire high-quality journalists, but to hire people to produce the clickbait that gets attention. Furthermore, The idea that a rising tide will lift all ships is not the case. BuzzFeed just laid off its entire newsroom. And BuzzFeed was long the proponent of the idea that you do things that get clicks so you can make money to have a real newsroom. And they've completely abandoned that model. So I respectfully ask for your no vote today.
Great, thank you. Good evening, Chair Gabriel, members of the committee. My name is Dr. Tapring Paquato, and I am representing Chamber of Progress today. It's a tech trade industry coalition committed to ensuring all Americans benefit from technological leaps. I would like to start by thanking the author for your engagement, your staff's engagement on this important, thoughtful issue and how to bolster local journalism. So my testimony today represents that journalism in this country is particularly important, and local journalism is really essential for a thriving democracy. However, I'm going to present to you 4 fatal flaws specific to this committee, not exhaustive. First, this bill requires platforms to line the pockets of large national news outlets. We know this because the local broadcaster and local publisher definition in the bill actually defined as, I quote, local, regional, national, or international matters, not just local journalism, which is supposed to be the primary goal of the bill. Second, this bill requires platforms to pay media outlets based on the number of times articles are clicked on or presented. This does incentivize the clickbait. It does incentivize sensational media. It does incentivize A/B testing of headlines, which is not local journalism, which this is supposed to be the primary goal of this bill. Third, this bill requires an eligible digital journalism provider to spend at least 40% of the funds, which we've already heard. What we didn't hear is the second part of that sentence, and maintaining or enhancing the production of distribution of news or information. So let me repeat that, and maintaining or enhancing the production and distribution of news or information. This does not require outlets to increase the amount of salaries to those local journalists. It does not require to increase the salaries of those with those funds. However, there might be outlets that may very well allocate 70% of the funds and take out those salary expenses that they were paying in lieu of whatever they want, paying executives or marketing or web development, but not journalist salaries. Right now, the bill does not specify it goes to increasing journalist salaries, unlike in a royalties situation, which is supposed to be the primary goal of this bill. Fourth and final, this bill does require companies to keep even harmful content, or else be the subject to litigation for changing the placement of social media content from one month to another. This non-retaliation provision essentially guarantees that platforms must carry the content provided by all eligible publishers, including the content of those publishers who have historically spread misinformation or disinformation. This bill does not increase the production of high-quality local news content, which is supposed to be the primary goal of this bill. To be clear, we're not opposed to supporting local journalism. This bill does not do that. There are alternative solutions, such as tax credits or subscription subsidies to local medias or outlets that hire local news and support them with fair wages. That don't reward peddlers of clickbait and misinformation or well-funded media news outlets.
I'm going to need you to wrap up. Thank you.
That actually don't report on California news. In closing, I thank the author for her sincere effort to increase reporting of local news. However, I implore you to join consumer advocacy groups, civil rights groups, and community groups such as ACLU, California Action, Cal Matters, Cal Chamber, EFF, TechNet, to not move this legislation forward tonight.
Thank you. Are there others in the room in opposition?
Becca Kramer Matter on behalf of ACLU California Action in respectful opposition.
Good evening, Chair and members. Naomi Padron on behalf of the Computer and Communications Industry Association in opposition.
Leah Nutake with TechNet, respectfully opposed.
Thank you very much. With that, we will bring it back to the committee. Let's go Mr. Bennett, Mr. Saley, and Ms. Irwin. Ms. Pappen, okay. Let's just start with Mr. Bennett.
Everyone will get their moment.
A few points. One, democracy is at risk. There's a vital role of fact-based journalism that we need to have and we need to maintain. And that vital role is being undermined by a variety of forces in the United States today, and therefore democracy is being undermined. I appreciate that a problem solver legislator has decided to tackle this, and it is daunting because the marketplace is a very hard place to try to regulate for an outcome. I think we see over and over again how difficult that is to do. It's hard to do this bill right, but it's important to try to do this bill because of the risk that we have out there. So I go into this with my eyes open. This may not work. And I think some of the issues that have been raised, I can see a number of places where, there could be a race for clicks over a race for fact-based journalism. There could be an investment in local journalism, and particularly if, as usually what happens in this, we get a chance to refine, make it better, et cetera. But none of that will happen if we just stay with our current status quo, which is the complete hollowing out of local journalism. And we see it in newspaper after newspaper, and we're fortunate that a few fact-based newspapers are still hanging on. So with that, I applaud the author for, again, taking a hard problem and trying to solve it. And I will support this, and at the same time recognize that I have my eyes open about the ability to get to the goal that I think you have and that most of us have here. Thank you.
Let's just go around the horn. It's probably easier that way.
I thought I was last, but I'll go next. So I think I asked you this earlier. This whole problem perplexes me, and maybe somebody here knows the answer. But I think I understand copyright law, and it has never, ever made any sense to me that these platforms can reprint copyrighted material without compensation.
So that's because under copyright law, there are certain things that cannot be copyrighted. One of those things is links, because that is an address to a website. And because that is a fact and not in a creative expression, that is not
I'm not asking about the link. When I go to Google News,
But they do not reproduce the whole article. They reproduce a portion of it. And that itself is also protected by fair use, because copyright is fundamentally in tension with the First Amendment. When you give someone a right over an expression, there has to be a way that you can critique that expression in order for the First Amendment to not be violated by copyright. Reproducing snippets, reproducing headlines in a way that allows people to find it is a fair use, because it is how you decide whether or not to click something.
Okay, would you like to add? Because I would take issue with that being fair use.
Yeah. And actually that was helpful, because that's actually not what the bill is about. We were very clear to
I'm not asking if that's what the bill is about.
Okay.
I'm just
asking. Why doesn't copyright?
Well, because I guess fair use, as I understand the fair use doctrine, if you're critiquing somebody, that's fair use. If you're satirizing someone, that's fair use. But if you're reprinting for the purpose of making money, which is what these platforms are doing, that is not fair use.
Making money does not make something not fair use.
There's a test. It's an element of the test.
Exactly, and so that's actually a novel question for the courts, whether or not a snippet is fair use. But
have they decided?
No, they have not. There's
Interesting.
a Perfect 10 case that's on appeal, because Goldman v. Breitbart challenged it.
Got it.
So it's actually an unknown. It's uncertainty as to whether or not it's covered. But because this isn't, Google and Facebook use it in so many ways. They use it in AI. They use it where there's no link.
Well, there's also a copyright case on the AI question.
There is.
Also.
It's also fair use. It is also fair use to use it in that.
So I'm just gonna jump in here for 1 second. Despite the green carpet, we're not in the British Parliament, so we're gonna let Assemblymember Barbara Cahan ask questions to whom she directs them, and then when you're asked a question, you can respond. Thank you.
So that's helpful that there hasn't been a case, because I obviously you have a legal opinion that it's not fair use. I I, having read the fair use test, think there is a very good case to be made that it is not fair use. Obviously, that is for the courts to decide, not for us as, well, it could be for us as a legislature to decide. Well, not us, but the federal government. They have copyright control. But so Europe actually took that angle, right? They've ensured that there's compensation for the copyright usage for these snippets, right?
Yes, exactly. And so they did a copyright directive in 2019 and it passed. What they realized was because they went to negotiate with the French and Google said, I'm not going to negotiate with you. You have to waive your right. So your right is only as strong as your ability to assert it. So if you're with that's why competition law is more operative in this case. Because if you have the copyright claim that you can go and hand to a monopoly, they're going to say take it or leave it. And then it's a Hobson's choice because you want to be found on the platform.
Right.
So you're of course going to waive your rights. So that's why it's a competition problem, and competition law applies here, and that's why it's about crawling and not necessarily any specific use, because you really can't measure any specific use that would quantify the corpus of the value of our content. It's immeasurable. We'll try to measure it, but it's pretty
right. So is the experience as you understand it in Europe, because it went into effect now at least a year ago, right?
It did. And what happened was when Google said that, we're not going to pay you, take it or leave it, the competition authority, Macron, got involved and said that's an economic abuse of power, their version of our antitrust law. And so what they did was they said, you got to go to the table and you have to negotiate.
Okay.
And so Google didn't. And then finally, the competition authority fined them $500 million and $1 million a day until they started negotiating. And then what happened was the arbitration and a backstop, a dispute resolution mechanism to have some sort of a conclusion to negotiations, because they have no incentive to negotiate, finally worked. They came to a deal, and it's a 3-year deal.
Got it. Okay, that's helpful. Thank you, because I really do. I think that fundamentally what copyright law is about is this notion that when I create a piece that belongs to me, that I get compensation for it. Again, there are exceptions to allow for other uses, but there's no question that if someone is profiting off of my art or my work, that I should be compensated for that. So I think that is what the author here is trying to ensure, and it's clear that someone's making money off the work, and the problem is that money isn't being shared equitably. This is not the first time today we've heard a bill that's trying to get at the fact that our federal government isn't doing their work in the antitrust space, which is incredibly frustrating, and I'll just keep saying it because that really would solve all of our problems. But I do think it's really important that we ensure that there is proper sharing. And as I mentioned in the AI copyright suit, I think this is only going to become a bigger issue as ChatGPT, I think, and other forms, when you ask questions, are going to do more of this copying and releasing of information that allows one to not go home to the news sources platform. And so I hope that this is broad enough to capture those future technologies as well. But I think the conversations absolutely need to continue because the press is so critical to our democracy, to our nation, to the freedoms that we enjoy every day. And it's a risk. And, it's interesting. As I was thinking about this bill over the last day, I was thinking about last week when we honored Holocaust Remembrance Day. And I think that this touches on something that hits so home for me as a granddaughter of Holocaust survivors, because when we talk about the proliferation of hate, it was the control of the media and the control of information that allows that to happen. And so as we talk about the end of hate, we need to also talk about what other things we need to be doing around that. And I think this is such an important piece of that. And so I'm happy to support it today.
Thank you very much, Assemblymember Wilson.
Thank you for all the conversation that's happened so far today from the witnesses and support and against, as well as the author and even my colleagues so far. And I know that as I've listened to each one of my colleagues so far this session, I'm sure that there will be more conversation happen. So I'm going to narrow mine to just one aspect. As I sit as chair of the California Legislative Black Caucus, and so one of my chief concerns outside of representing my district and ensuring all Californians are represented particularly Black Californians, how they access media, how they get their information, and as well as the organizations that are involved. And so, I rely especially on these issues heavily on hearing from, Black organizations on this topic. And so I know California Black Media hasn't weighed in a support or opposed position and a neutral position. I believe the national organization has. And so my only concern, not only, but the main concern I have with the bill is in that vein, and ensuring that they are not left out of the discussion at all. From all aspects of it, whether it's making sure there's protections within your bill, and as well as ensuring that any resources that are given as it ties to organizations that are representing and definitions, that they're included and not excluded. And that's very intentional. Mm-hmm. And not only will that be impactful to Black media, but all ethnic media in general, because usually we're the ones left out. Right. Mm-hmm. And so I just want to make sure that they're included and be the voice for that today, because as I said, I know the different members are going to have different aspects of it, yep. But I just want to make sure that's at the forefront as you work through this process, that you're keeping them in mind, and that I'll be holding to. And so that'll be something that if it gets out of this committee, I want to look to before, I vote on it again. Yeah. Okay.
Well, if I might, Chair, I appreciate that. It's an extraordinarily valid concern, because I think what we've seen in other iterations of this, they have been left out. And so we were really intentional looking at the other models that our definitions are very inclusive, that we're capturing the smaller papers, the ethnic papers, the nonprofit papers, and others who provided incredible service for those constituencies. So, and we've had conversations. I think this is obviously the first committee hearing. I've spoken directly with Regina and others. Will continue to do so, and we'd love to have you as part of those conversations as well, just to ensure that that aspect is that we meet that threshold to your standard and to others, because I think that's very important.
I just want to, sorry.
We're going to go next to Assemblymember Saley.
Thank you, Mr. Chair. Ma'am, I missed it. What organization are you with?
The Electronic Frontier Foundation.
Do you receive money from Google?
I honestly don't know, because as a member of program staff, I don't see how we get our money. I do know that the majority of our money comes from individual donors.
Okay. I'm struggling to understand the arguments of the opposition here. Our journalism is dying. Local journalism is dying. I see it in my own community. There's like one reporter that covers 2 counties of politics, and often he just ends up reprinting press releases. It's not really doing anyone a service. And you're not going to convince me that Google is not benefiting and profiting off the backs of the work of journalists, because they're out writing the content, and when people are searching for article or topics on Google, Google is scraping the content from those articles and summarizing it and providing it in their search window, and they're benefiting because they have Google ads on there. They want to keep our eyes on their webpage. And Google made $280 billion last year. Billion. That's the budget of the state of California. So they're making a lot of money off us, off our data. And so I think they need to pay. They need to pay for the content they're profiting off of. With that said, I think, Assemblywoman, you have worked extremely hard on this. I've never seen anyone work as hard on a bill. And I know we've had some conversations, and I totally agree with what's happening with Google. I have reservations about the bill applying to social media, where the news agencies are voluntarily putting their content on there, and so I don't think it's a fair comparison. So I do look forward to those amendments in the Judiciary Committee, and I intend to support the bill today. And I also echo the importance of having a free press. It's vital to our republic, our constitutional republic, that people have access to objective information. And I think journalists need to do better too. I think there's a lot of journalists who are activists, and that really turns people off. We want some objective fact finders. We want you to hold the government accountable. We want you to hold us accountable. To my knowledge, Ashley Zavala is one of the only reporters in this Capitol that does hard-hitting journalism. There should be 20 of her. Is there a reporter in the room? There's no reporters in the room. I mean, the topics we've covered
Speaking
are
as an activist journalist, I'm testifying.
Activist journalist as well.
There's no reporting, and that's a disservice to the people of this state. And so I want to to ask you guys to do better, and hopefully these funds will go to hiring more journalists or paying them better so they'll have the resources to actually do the important investigating work to hold government accountable and not be a mouthpiece for government or be activists. So, yes, if you can.
Would you
yes,
like me to
sir.
respond
yes,
to
you
that?
Can respond.
Thank you for your comments. Organizations like the News Guild, a union which, was created through activism, so I can only criticize activism so much. I'm appearing here as a leader of my coworkers and as a leader for journalists in California. We got our foundation in the 1930s at a time when the press was dominated by oligarchs, extremely wealthy individuals who controlled what people read in the news. And this was also at a time of the rise of advertising, and journalists in these newsrooms wanted to see stronger professional standards in their work. And so one of the contradictions of having a free press in this country is that it has always been tied to a commercial foundation, and that has always brought criticisms that the press has been sensationalist, it's been, biased toward advertisers or to the ownership. These are issues that have been with us from the founding. You go back to the founders, and they're complaining about newspapers at the same time that they're imposing postal subsidies to make their distribution easier, because they understood that to have a free press, you had to have the material preconditions of having a free press. And so in order to have those conditions, you need to be able to get it distributed to people who would see it. And so part of why I'm here and part of why unions like mine exist is to try to boost those professional standards and try to be a counterweight to the commercial realities of the way that we've structured free speech in this country. That's why you have organizations like Society for Professional Journalists. It's why we have ethics codes. It's why we have ethics guidelines that a lot of publications publish online. So, I'm with you on the need for more and stronger professional journalism.
I appreciate that. And your comments about oligarchies are important. I think we're living under a tech oligarchy right now. And so I do have concerns about that. And I want journalism, but I don't want yellow journalism. So there's work to do on both sides. And there's no question pending. Thank you, Mr. Chair. That concludes my comments.
Thank you, Mr. Lowenthal.
Yeah, I'll be very brief, Mr. Chair. I want to commend my colleague from Orange County who encapsulated all of my thoughts. Thank you. Riverside County, not Orange County. Riverside County, excuse me. I'm 0 for 2 tonight, aren't I? Sorry, guys. And also my colleague from Orinda. I'm right about that one. I know where you live. There's been a really interesting evolution of the internet as a whole, as we know it, where, there was a complete erosion of intellectual property out of the gate. And we saw it everywhere. We saw it in music, we saw it in film, we saw it in journalism, we saw it in everything. And over time, a lot of those, sectors have worked very hard and very diligently to get that back. And a lot of that was driven by, industry itself, the music industry, the film industry, and all the associations around it. And basically what we're talking about here is licensing, really, more than anything else. I will say the lack of journalism, or the lack of robust journalism on the local level affects the way that we do our jobs. It really does. We all feel it. There's no accountability in our districts. And there is on the national level to some degree, but when it comes to governance in California, we are affected so severely by it. And the other thing is that, with the system that we have now engenders disinformation, to my colleague from Riverside County's point, without any consequence. And that degrades all of our society, and it degrades the discourse completely. I think this bill is wonderful. I appreciate the spirit that the author is taken to continue to work on it. I think that this is going to be dynamic and is going to need work over the course of time. It's not going to be solved in this cycle, even if the governor does sign it, which I hope he does. I hope that you would consider to add me as a co-author to this bill. And very proud of you and proud of our body for taking this on. Thank you.
Thank you. Mr. Vice Chair.
Thanks. I spent a lot of time on this bill, and really appreciate the author for reaching out to me and having discussions. And I've talked with Danielle Coffey. All right, spoke with her as well, and a lot of people around this situation. And I've been thinking a lot about this. I went to, people might not, first of all, don't worry about calling him from Orange County. I get called Josh Hoover and Jim Patterson on a daily basis, so you can call him from Orange County. It's not a problem. But if you go to Sacramento Bee right now from a desktop, I don't know if it's the same on a mobile device or not, but about 50% of the articles up there are affiliate. It's some kind of, strange content almost, and they're buying it, and you click on it, and then when you go back, it rotates it out, and I don't exactly know what's going on there, but these publications are using this affiliate information not because it's clickbait. I mean, it's actually not really useful information, but because they need to drive the revenue for their publications right now. And in a lot of ways, I also appreciate what all the online platforms do. There are a lot of articles out there that I wouldn't even read if it wasn't for various shares or them getting to know me a little bit and figuring out what I actually like to read. Some people up here might think I read different things than I actually read. I do read occasionally, as long as it's 5th grade reading level. But I do have some questions for Ms. Coffey, and kind of goes on what Assemblymember Saley was going. But you had referenced that there really aren't any click-throughs on Facebook. And we did talk about this a little bit. And that particular platform doesn't show snippets unless people are, or the publication themselves are grabbing the information, putting it in the post. I mean, it's basically just the subject or the title of the article. So how would you determine what kind of revenue from something like that, from those shares, would be owed to publications from shares?
So how the bill is currently written, you would go collectively to an arbitrator, which you can do collectively. You can't negotiate collectively with a party, but you can go collectively to a state-sanctioned arbitrator, and you would determine. Well, it's baseball-style arbitration, so what it is it's final offer arbitration. Both parties say what they think their value is that's attributable to the news content, that's attributable to the advertising revenue of the platform, in this case Facebook. And then the arbitrators would pick which final offer most closely resembles fair market value. And that it's the gold standard of our dispute resolution mechanisms, because each party is incentivized to be reasonable for fear that the other party will win. So it's worked in Australia and elsewhere, but what you're asking is with Facebook, how would you, I think you're saying, how would you distinguish between what you post on Facebook that you would say is your value, that you are owed, that the news publisher is owed, versus non-posted, self-posted content? Is that what you're asking?
Well, the Facebook is social media, I think in general, is a much different platform than other platforms we're talking about in terms of, it's not showing you the information, first of all,
right.
Unlike other platforms. And then it also, it's building, I don't think it's a secret. I have no idea how it actually works, under the hood, but it's building some kind of profile on Joe Patterson and what kind of things I like to read and, how long I spend and whatever it's doing, way beyond my pay grade. But at the end of the day, it's harder to quantify, I think, what the direct impact is to something like that than actually using the content.
I'll give you my rudimentary answer because I'm not an economist, but essentially what you would do is you would look at how much revenue is generated that Facebook is generating off of the content that's attributable to news, that portion of it that they are profiling you for and targeting you with ads, and the posts come up. I don't know either. I don't think any of us actually know how their algorithm works. That's not transparent. But they give you a feed. Everybody's is different, and it's based on your user experience. And then that data goes back, and nobody knows the value of a single piece of data. So that's why it's difficult to figure out how much of it is attributable to news. And so what we've done and what we would demonstrate to an arbitrator is a quantification by triangulating, like I said, I'm not an economist, by using several methodologies to be able to determine what the value is of data without knowing what the value is of data. And it was a very, very difficult undertaking. And we're ready to go to arbitration and show them that. But it is very complicated not knowing what data is worth.
And I would just add to that, because I know you and I have talked about, as with others, the sort of Facebook versus Google aspect of this. There's still value to Facebook when they repurpose news content, because they want to keep eyeballs on that news feed screen for as long as humanly possible, right? So they want to promote content that is exciting to people, draws them in, et cetera. So there's value for them to have that, and then they run advertising against that. I think there's a question around what is that value, and I'm happy to explore with you and others, if this bill moves out of committee, how do we differentiate sort of Google versus Facebook or search engines versus social media, because it is a little bit different.
Yeah, I have the attention span of like my kids, and that was a complicated answer. Hopefully an arbitrator would be able to, get in the weeds on that a little bit. But, we've talked about these concerns. I think, when you take a product that has very clearly they're using the actual content from these writers is distinct from whatever it is social media platforms are doing with the information. And so I think that's kind of the one sort of hang up I have on it. But I will say that I think what you're getting into is valuable. It's important. I don't think it's something that the discussion should not end today. Mm-hmm. And you've shown a willingness more than, I've shown willingness to other people. I think a lot of people have shown willingness to other people of all parties, of all walks of life here in this building to work on this item, and I really appreciate that. And I hope, if it gets out of committee, it sounds like you're stuck with the guy from Orange County again, but in Judiciary Committee. But I hope you continue those discussions with him, and really appreciate that. So thank you.
Thank you.
Assemblymember Pappen.
So I'm not from Orange County. Just let me get that out there. But where I am from is somewhat important to my attitude towards the bill, as you well know. Coming from tech land, and my district is comprised with a lot of tech. So I appreciate the discussions that we've had. One thing that we totally agree on is that there's a very important role to be played by local newspapers. I subscribe to mine. They play a very important role in local government and covering state government. They come online at 5 a.m. every day, and I read them. And I know newspapers long ago adopted paywalls to sort of reap some of when folks were trying to get at their content, and I applaud that. It's certainly a way of doing it. I am concerned about money going to big conglomerates. I got to tell you that, and I think you can work with that. I don't, if you get it in the hands of journalists, that's where the money really should be going. They are underpaid. I have some issues about level of professionalism as well, but that does not deter from the importance that they play in our democracy. As you know, I'm the only Greek in the legislature, and I take pride that my people invented democracy. So it is of great import to my soul, as it were. So the discussions that we've had, to follow on with somebody named Patterson, JP, is that, yes, not all tech is created equal. And as I understand it, Google does a lot of scraping. That is an active thing that Google does to get content and then entice people with content. Social media is slightly different. You have users that seek to like an article and then repost it. So because there's different activities to getting it out there, I look forward to seeing this in Judiciary, mm-hmm. and maybe a bill that sort of addresses those nuances and those differences, because I do think it's important. Yeah. And, I mean, scraping is a totally different ballgame. So I appreciate you've been very open about taking a look at this. Yeah. And so I'm willing to support the bill today with the concept that we look at the nuances. Not all tech is created equal, and we figure out what might be reasonable. But I think you can work with where the dollars ultimately end up, because there are antitrust issues with how much consolidation there's been in the media. And I love my local newspaper, and I would go to the ends of the earth to make sure that they continue to play the role that they play. I think people get really twisted watching a lot of news on TV about what goes on in DC, but what happens locally affects your everyday life more than you could ever imagine, and newspapers play such an integral role to that I'm here to be their big cheerleader. So thank you, though, for continuing the discussion.
Yep. No, and if I could just react, I appreciate that. I give you my commitment. I'm going to continue to work on that nuance, as we've discussed, as a couple of members, I think, have raised the same issues. And so I know we have the next hurdle, judiciary, so we'll have, I think, continued conversations.
I'll see you
on
there.
that as well.
Thank you.
I'll just be very brief and just ask a clarifying question. I appreciate the author in terms of, we've had a lot of conversations as well. I feel like there's a conflation, even in the questions, about having platforms negotiate with publishers for the use of news as the copyright issue. And then there seems to be another bucket of the conversation of taxing or charging or taking digital advertising and using that revenue to provide to news outlets. So are these two separate issues, or are you just rolling everything together? Because I think if the conversation is somehow compensating journalists and getting permission to use their copyright, that's one thing. If the goal is to just, the platforms are making significant amounts of revenue on digital advertising, and now we want to kind of redirect that to newsrooms, then that seems to be two separate issues. Am I understanding that correctly?
Well, so when there's a payment owed to another party, there's different mechanisms by which you can enforce that payment, and that happens across the board in anything. There's retransmission consent for broadcasters, and that's a negotiation over compensation. But then you could also license content to be able to use in a clipping service. So it depends on it. It's just a mechanism that would enforce that payment. In this case, the payment is enforced by, and you can almost think about it as a quasi-property, because you're enforcing the payment to be able to get the value of what it is that's owed to you by the party who's receiving the benefit of that content. And it's confusing because it's about content. So when you think content, you think music, you think other things that are usually licensed. Not all, but mostly there's usually a license for that. But actually in this case, there is oftentimes a transfer, an enforcement mechanism that is not a license, and it's another compensation mechanism, like this would be arbitration, and that exists in many other cases. But I think the confusion comes because it's about content, so you want to go to licensing.
So this bill certainly has evolved. It started out as kind of a fee, and then now there's an arbitration feature. And since you brought up kind of the music, the other areas,
sure.
Are there parallels here? Are we recreating the wheel here? It seems like as we debated I'm dating myself when we talked about like Scour and downloading and all that stuff, and now we're kind of in the Apple Music world. Is this seen in a similar vein, or am I comparing apples and oranges?
Well, I think that the point, Assemblymember Bauer-Cahan, and I'm sorry if I'm butchering your last name. Oh, okay, good. The point that we were discussing earlier, whereas if you license for a specific use of content, it does an injustice to the uses of the content of news here, because there's so many ways in which our content is used, and the most recent of which is AI, where there's no link. There's no attribution. There's nothing that actually, there's no business model for us in AI. And we're used in a tremendous amount of nobody else records real life content like news publications. So it's used, it's valuable, but we need to get paid for it, and all those logical things line up. And then it becomes, what's the enforcement mechanism in order to get paid for it? And here it would be arbitration. If it was music, I won't go into music, but it would be something different.
So just to be clear, they're apples and oranges.
Pretty much apples and oranges, yeah.
Okay, thank you.
Yeah.
I think everything's been said. And I have a bill.
Okay.
Still.
All right. Well, I just want to thank I want to thank all the members of the committee for the very thoughtful conversation here, and want to thank all of the witnesses on both sides for the thoughtful conversation. Want to thank the author for, first of all, your work in this issue, your agreement to take these amendments in Judiciary Committee. Appreciate your approach to all of this. I guess a lot has been said, and maybe Assemblymember Irwin is right that everything has been said. But I will just agree with you. I think that a free press is absolutely vital to our democracy. I think it's a cornerstone of our democracy. And there's a reason that the press is specifically enumerated in the First Amendment to our United States Constitution. There's a reason that the press is specifically enumerated in Article 1, Section 2 of the California Constitution. And that's because the people that wrote the US Constitution, the people that wrote the California Constitution, understood that the press was vital to our democracy. And one of the things that this committee has struggled with and grappled with is how tech is changing the way that information flows to people, the way that people receive information. Certainly Assemblymember Bauer-Cahan talked about some of the historical warnings that we see about the control of information and the importance of combating misinformation and disinformation. That's something that this committee has done with previous things that we've worked on. And so I just appreciate you, Assemblymember, for addressing this issue. I know that there's still some more work that needs to be done here, some details that need to be filled in. Some of that is outside the jurisdiction of this committee, but you have shown remarkable skill as an author and a legislator in bringing people together. I have tremendous confidence that you're going to continue to work with folks on all sides of this issue to craft something that works. But fundamentally, this is something that we need to do. And I guess I would finally just conclude to our journalists in the room. I hope that this sitting in this hearing has been enlightening to you about the work that we do here and the frustration that some of us feel with the way that state and local government gets covered. And I think there's a lot of reasons for that. But we don't call each other names quite as frequently as they do in Washington, D.C. But I do think we try to work through a lot of issues that people in California would care a lot about and have a lot of opinions about and have a lot of and would want to know about. And so the things that we can do to better promote local journalism to help sustain a robust and free and independent press that is going to critique and hold those in power accountable, whether inside and outside of government, I think is critically important to our democracy and the way they're going to navigate these very challenging times with the rise of technology. So again, Assemblymember, super appreciate you. I believe some time ago we had a motion and a hearing, motion and a second. So we had a motion by Assemblymember Bauer-Cahan, a second by Assemblymember Lowenthal. I'm happy to recommend an aye vote on this bill. Appreciate you very much, Assemblymember. Would invite you to close.
As mentioned, I think everything's been said, and it's going on our 9th hour of this hearing, so just respectfully ask for an aye vote.
All right. With that, Madam Secretary, please call the roll.
Item number 18, AB 886 by Assemblymember Wicks. The motion is due pass to the Judiciary Committee. Gabriel.
Aye.
Gabriel, aye. Patterson. Not voting. Patterson not voting. Bauer-Cahan. Bauer-Cahan, aye. Bennett. Bennett, aye. Saley. Saley, aye. Fong.
Not voting.
Fong not voting. Irwin.
Aye.
Irwin, aye. Lowenthal. Aye. Lowenthal, aye. Pappen. Pappen, aye. Wicks.
Aye.
Wicks, aye. Wilson. Aye. Wilson, aye.
9-0, your bill is out.
Thank you.
And we will go on, congratulations, we will go on to, I think, our last bill, Assemblymember Irwin.